This is WPSL Port St. Lucie.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning, Treasure Coast and beyond. This is another edition of Ask a Lawyer. I'm Stuart Address, and I hope you will call me this hour with whatever questions you may have. From all the calls we get in my office, I know that people tend to have lots of questions, so give us a call at 340-1590. You don't have to limit it to whatever topic we're talking about, and if I can't answer it, I'll pretend. No, I won't. I'll tell you I don't know what I'm talking about, and we'll see if we can help you with what I do know what I'm talking about. Anyway, I do want to thank everybody who is listening. I've been doing this for a little over 6 months now, and I have come to realize that people actually listen. We have people who call and say they're regular listeners. We had 2 folks in the office today that listen to the show, and it's nice to hear that people actually listen, that they either find it informative, amusing, or just can't believe they're listening to a lawyer. So, thank you.
Any way you look at it, it's thought-provoking.
It is. And for all you who are listening, loyal or first, second-timers, whatever, I will say this. Friends, Romans, countrymen, lend me your ears. Actually, the ears of others. Tell your friends. Tell your neighbors. Tell your enemies. Just don't tell your adversaries. Anyway, I also wanted to talk a little bit about something that happened in my office yesterday before I get into the meat of the show. And it shows really what law firms go through these days and technology and its impact upon law firms. I woke up yesterday morning to try to access my office from home. And I found that when I went into the file that says Client Files, to be continued, folks, we have Gary on line 1. Hi, Gary. How can I help you?
Okay. Last year, I was diagnosed with this lymphoma, and I went to the hospital, and I had good insurance. I had Florida Blue.
Okay.
I guess it's HMO, and it was Obamacare. And anyways, they took care of everything. But all of a sudden, I got a bill from this company from Fort Lauderdale for $6,300 for pathology. And they said, Florida Blue said it's out of network, we don't cover it. And for the life of me, I looked at who signed it. The one doctor, I never saw him before. And the other one, I don't even know who it is. And it was the hospital, I guess, that sent it to this company in Fort Lauderdale.
Right.
They could have sent it to somebody who was in network.
You're absolutely right.
And why do I have to pay that money?
Well, I think you may have a good argument. We're hoping not a lawsuit. The first thing I would do is probably talk to the hospital. I always say in writing, because they get scared of in writing because it means it's of record. And I would make the point that you've made precisely. Without my knowledge, I come to you, you're in network. Without my knowledge, you send whatever it is you sent to an out-of-network provider, and now my insurance won't pay for it, and I'm stuck with this giant bill.
And I'm going to go in collections, I figure, and
Right.
my credit was beautiful. My credit has been stopped.
Well, we want to stop it
165.
before that happens. And I think you write to them and you say, look, I either want you to write it off, which means you solve it with the out-of-network provider, you the hospital. I want you to intervene on my behalf. Otherwise, the standard phrase is when you're not really sure what the cause of action is, otherwise I'll consult an attorney and take legal action. And see if that helps. Very often it will.
Sometimes that may be just your deductible, because I've had that happen in the past too, where they've paid everything
No,
but
my
one
deductible
doctor.
was
He's right. This is out of network.
Okay.
And
No,
so,
no,
That's
my
happened too.
deductible was met.
right.
It was
Well,
all
his
Okay.
in-network deductible was satisfied. He doesn't know what's happening, and they send it out of network. I completely understand.
Exactly.
And so
That's
if that
exactly what
doesn't
happened.
work, even that or even simultaneously, I would send a letter to Florida Blue, saying this was done without my knowledge. I went to an in-network provider. You, Florida Blue, this giant, massive insurance company, you're the one that has contracts with all these folks. I'd appreciate if you intervene on my behalf and see if between you and the hospital this can get resolved. Now, it won't always work, but very often that will work because
I appealed.
it's not an unusual
I did
situation.
appeal it.
You did.
I appealed it. But they sent a letter back saying, we've looked at this and it's just out of network and we deny it.
Well,
We deny- we're
see,
not-
the appeal's not the really. I mean, I agree. It's a good thing you appealed, but the appeal is really not the issue because it is out of network.
Uh-huh.
What is the issue is not whether they are right or wrong, and that's what an appeal is for. The issue is whether or not something can be done equitably to assist you because the out-of-network portion was without your knowledge or consent.
And this was an in-hospital
Right,
situation. I
right.
mean, you're at their
I was
mercy.
unconscious.
Yeah,
I was,
they.
Right, and if look, if it was something that could only be sent to a out-of-network provider and it was absolutely necessary, I basically, I understand that's life and death. But if it's something that could be sent to an in-network provider and the hospital chooses to send it to an out-of-network provider, I think there may be a claim against the hospital. And so I think starting out, with a letter to the billing department at the
Can
hospital.
you write a letter for me?
Here's the problem. Here's what I tell everybody who calls my office with that question, because I get that question a lot. Sometimes people will come into my office for a consultation, which is like $375, and they'll say, "Can you write the letter?" And I'll say, "Unfortunately, in my office, we really can't open up a file for less than $1,500, and you don't want to pay me $1,500 to write a letter."
No.
What I could do for you in a consultation is almost sort of what I've done for you here on the phone for free, which is give you bullet points of the things that I think you should say to them, and some of the buzzwords. It was your choice to send it out of network. It was without my knowledge or consent. I'll consult an attorney and take appropriate legal action. Can you just resolve this? Mm-hmm. And if they do business with this out-of-network provider substantially, they may just call the out-of-network provider and say, "Look, let's just deal with this. They charge you $6,000, okay? You charge us $1,000, it's probably the contract rate, and we'll pay it. And this way, the patient who came to us as an in-network provider, he doesn't pay anything, and we get him off our backs."
Any correspondence that he does with the hospital, should he also send to the insurance company?
I would copy it to the insurance company.
Okay.
And in fact, I'll give you one other person to copy it to. The insurance commissioner for the state of Florida.
Okay.
Now, they're not going to do anything with it, but at least let everybody see that
You're sending it
that
there.
that one of the next steps may be an administrative complaint.
So when I go to the hospital, who do I send, to the administrator or the person?
I would send it first to
Billing?
billing. I would send it to the billing
Billing.
department. Let
In the
them
hospital,
them
okay.
send it wherever they want to send it. I would
Okay.
start with billing for you.
It's not worth going in and talking to
No.
nobody. You're saying it's
Well,
not.
look, it's never hurts to go in and talk. But if you can't get what you want through talk, then you've got to put it in writing. So not only is there a record of it, but sometimes the writing will get you what the talk wouldn't get you, because now it is of record, and they know that if any action is taken thereafter, whether it's legal or administrative, there's a record that they ignored it. Whereas you going in and talking to them, we have no record that he ever came in.
I got you.
Now, it's an outside entity.
Yes.
Okay, should everything go to them as well?
No.
Okay.
No, the outside
I know
entity.
they're trying to collect their money.
Yeah, the outside entity didn't do anything wrong.
Okay. But they're the ones that are going to turn you into collection.
That's right, and you want to try to
they're
solve.
getting ready to.
Yeah, you want to try to solve this before that happens. And if it does go into collections, let's look at this in advance. The first thing you do when you get a collection letter is you write a letter back, certified, return receipt. Please do not contact me again, except to sue me. That stops all the nasty collection calls and collection letters.
Mm-hmm.
And please do not contact me pursuant to the Fair Debt Collection. I always mess that one up. The Fair Credit Billing Practices Act, I think is what it's called. My paralegal will know for sure. You use the buzzword and you say, don't contact me unless it's to sue me. And they are now not allowed to contact you, call you, write you, harass you, anything, unless the entity that they're doing it on behalf actually sues you. But if you find that happens, immediately get in touch with the credit reporting agencies, the major three, and tell them you want to put a comment on that report, that item, because you're entitled to up to 250 words on any entry on your credit report. And the only thing I would simply say is, this is an out-of-network provider that I was unaware of because I was unconscious when I went to an in-network hospital, and it's presently the subject of a dispute.
Yeah.
And that way, at least if, for example, if you go to buy a car, and this has knocked your credit rate, your FICO score down 20 points. At least when they look at your credit report, they see the comment, and if it's a rational comment, a lot of lenders understand, and they won't hold it against you.
I got money in the bank. My house is paid for, so I don't really, my credit. I mean, I don't really need the money. I mean, I don't need to borrow any money or use my credit for pretty much anything. So I don't really care.
I know, but it's always nice to have a nice credit rating.
I know, and I did my whole life until this.
So why don't you take those steps? If it doesn't work, honestly, give my office a call, and we'll see if we might be able to help you further. Okay. But hopefully this solves the problem, and you've asked a lawyer, and you don't have to pay a lawyer.
Right. Thank you very much.
You're very welcome, Gary.
I'll write them a letter.
All right, take care. Bye-bye.
Yep.
That's a common problem. It's unfortunate.
And the other thing with medical is, and this is somebody probably who they could even be out of state, that this, they read the tests,
right,
and then they bill you.
Right.
But
and medical is a topic for today. Not this medical, but medical.
They go so fast to collection. I mean, it'll make your head spin.
That's right. And so you do want to try to resolve it as best you can. And if that doesn't work and you're forced to hire an attorney.
Well, the $1,500 for the letter is better than $6,000 going to somebody.
That's if the letter works.
Yeah.
Depending upon the facts, it's always about the facts. Here, I think there are good facts. I mean, guy's unconscious, and if there was an available in-network provider that the hospital is contracted with, I don't see any good explanation for sending it out of network.
Well, I had the same company that he called about, and I went in for a really bad ear infection, and they took care of me in the emergency room, and they told me when to come back and where to go. So they have the hospital has those little offices where you go to have like X-rays and things like that. It was an earwick, which they were going to remove. Your insurance won't pay for that. You people put it in. I came back to you. So it was either go to the emergency room and have it removed. Right. Actually, I walked out the door, pulled it up myself, and just called it a day. Called it a day.
All right. So anyway, I was telling you, we had a little incident yesterday. I turn on my computer. I go to my client documents, and they're all gone. There isn't a single client document for all my current clients or my past clients.
Did you panic?
Panic is not the word for it.
Yeah.
I yelled. I screamed. I threw tantrums.
And then you had to go, don't touch anything because you don't want to make this permanent.
Then I alerted my paralegal.
Don't touch anything. Don't make it permanent.
And what happened was our server failed.
Okay.
It has 3 hard drives. Apparently 2 of them failed. When one fails, it's okay. When 2 fails, collapse.
And everything's in there.
And you have to hope that you can retrieve it.
Wow.
So I'm terrified that,
everything's gone.
I mean, recreating that is a nightmare, and I don't want to ever do that. I think I quit law in I'd go into the second profession I'm thinking of, recreating anything I hate. So anyway, we have an IT individual that we have utilized, and he gave us a quote for a new server, much faster server because technology improves over time.
Yes.
And I was about ready to pull the trigger, and my heart was sinking because it was a pretty penny.
Yeah.
Right before the
Happy holidays.
Cheryl, I'm taking your bonus back. I don't think she'd give it to me. She's nodding her yes. I'm sure right now she's nodding her head.
She's like, it's spent. Yeah. Sorry.
And then we called somebody who was at one point the coach of one of my son's Little League teams.
Okay.
And he's an advertiser here on WPSL.
Oh, yes, he's near and dear to our hearts.
A faster PC.
Uh-huh.
And we called Brian, and my paralegal called Brian. And I had her, drop the name. I said, make sure you tell them that he was the coach of my son's Little League team. And we need help now. And Brian came. Brian looked at our system, and he said, look, yeah, your server is older. It's 8 years old. But he said, you don't really need to replace it. Not yet if you don't want to. You can replace the 2 hard drives that failed. We can put in a solid state hard drive to protect X, Y, or Z. And
you're like, yes, please do it.
And I can't pretend to give you the technical stuff because I don't understand it. We can make this a lot faster because he said, I said, well, the other guy said the new server is like 100 times faster than what we have. He says, well, that's true. I said, well, tell me something. As a layperson, for what I do, would I even notice it? He said, well, the boot time would be faster. That I understand. A couple other things would be a little faster. Okay. He says, but we can make it faster. I said, it reminds me of the $6 Million Man. We can improve it.
They are a faster PC.
So, yes. So he told me what they could do. And it was, all in all, much less than getting a new server and quicker. And so Brian is maybe at my office right now for all I know. If he is, hopefully Cheryl grabbed him the second I mentioned his name. So he's hearing that I'm actually giving him a plug. But he did help us tremendously yesterday. He got the server online temporarily, even with the 2 hard drives that failed.
Okay.
I mean, I don't know what he did. He said he went into the motherboard and did this and went into the BIOS and did that. But by the end of the day, we had been calling lawyers asking for extensions because we had court documents that needed to be filed. And by the end of the day, our server was actually up. So I owe him a great debt of thanks. And, folks, he did save our bacon. So I know he has a show here. He tells you a lot about computers.
And he said, back up, back up, back up, back up.
Well, we do that.
Okay, good. That's good.
Oh, I'm not that foolish. No.
Well, it's that. We're gonna.
Well, it does it automatically. We have a backup system.
Okay.
So it does it automatically every night. 3 o'clock when I'm not there, I'm not supposed to be there. I'm not there. The only time I've ever been there at 3 o'clock in the morning was once when we had to pull an all-nighter to get a brief filed with the 11th Circuit Court of Appeals in Atlanta. Those things require because if your staple is out of order, they'll bounce it.
Okay.
So those things require all-nighters. But that's the only time I think since law school that I've pulled an all-nighter. All right, so what are we going to talk about today? We're going to talk about something that I get call after call after call about. And for the most part, we have to tell people there's nothing really we can do for you. And it's really the truth.
Yeah, well, it's going to happen.
No, they have a perfect claim.
Yeah.
So why is there nothing we can do? If they have a real claim, why is there nothing we can do? Because there's a certain law that Congress passed that didn't give you the right to sue. So what good is it? So we're going to talk about that.
What if the person that you need to sue really doesn't have anything to collect?
Oh, we're not even discussing that.
I mean, there's no case there either, right?
Well, sometimes no. Sometimes yes. Anyway, we're talking about HIPAA, folks. I know you all know what HIPAA is. I know it affects each and every one of you who is listening. I know that each of you have at some point recently gone to a doctor or gone to the hospital or gone to a walk-in clinic or have received a prescription, and they all make you sign a HIPAA statement that they've advised you of your HIPAA rights. Of course, you'd never read it, and you sign it anyway, but it's not like you can read it and change it. It's a federal notice. So they sign it or we can't treat you.
I was just going to ask that.
So you sign it.
Can you refuse?
No.
Okay.
You can refuse it. They'll say they can't treat you. So you sign all these things that say, oh, yes, they gave me a copy of the HIPAA notice. What good is it? I can't tell you how many calls we get from people who say, my medical information was told to X, or my employer found out Y, or my drug test results were leaked, or a nurse who was being a busybody went into the computer and looked at all my results and started gossiping.
I have a relative works for a pharmacy in another state who tapped in to see what kind of medications the family was taking.
No,
she did.
She
did.
Yeah, but that's a HIPAA violation.
Yeah.
So most of the time you call, and you're right, they were wrong. But you haven't been hurt.
No.
Okay? It doesn't mean you don't really have a right to a remedy, because they still did something wrong. But at least thank goodness you haven't been hurt. Other times we've received calls, they have been hurt. We threatened to sue one doctor's office for defamation because an office manager went into a employee's mother's file because she was curious about the mother's health situation, and then started telling people in the office, incorrectly by the way, that the mother was an alcoholic, and the employee ended up resigning, humiliated. It wasn't even true. She tried to tell the doctor. Doctor didn't want to have anything to do with it, so no corrections were being made there. The person wasn't even being admonished. So we get a call, well, isn't this a HIPAA violation? Yeah, it's a HIPAA violation. What can we do about it? Well, you're not allowed to sue under HIPAA. And people go, huh? What?
Of course.
Folks,
so who does it help? Who does it really help?
I'm going to get there.
Okay.
I'm going to get there. So why have a statute that you can't sue under? I don't know. I'm not a legislator. All I know is when we talk a little bit about the remedies, you'll find that for the most part your remedies are administrative complaints. And the provider can be sanctioned, fined, but what does that do to help you?
Well, if they were fined, who gets the money?
Well, the state.
Okay. So
it's not like you're going to get anything.
Yes.
But recently, and we will get to a couple of examples maybe this week or next week, recently lawyers in several states have become creative. And that's what lawyers do. Lawyers, good lawyers, look at a problem and say, well, if I can't get the solution going straight ahead, let me get the solution taking a 200-mile detour.
Mm-hmm. So there's always more than one way to get there.
Usually.
Mm-hmm.
And so there are lawyers that have been suing now for breach of contract, negligence, invasion of privacy. These are all common law torts. Well, contract isn't, but, invasion of privacy, negligence, these are common law torts, as opposed to statutory causes of action. So they've been trying to circumvent the HIPAA statute, which does not allow you to sue under HIPAA. And their argument has been, well, doctor, when you agree to see this person, or hospital, when you agree to treat this person, there is an implied contract that you're going to follow all applicable privacy regulations. You breached that contract. And our proof is the HIPAA statute. So we're not suing under the HIPAA statute, but we're using HIPAA as your standard of care that you breached. So similarly for negligence, attorneys are beginning to argue that you negligently breached the information that was disclosed, and you should be responsible for that. Invasion of privacy is a great tort. There's 5 different aspects of invasion of privacy. But for the most part, it's the publication of personal information about yourself, whether it's true or not. I mean, there's one aspect of invasion of privacy where it's not true, and there's another aspect of disclosing private information even if it is true. You're not a public figure. So they've been going that way with some limited success. And that's all it really takes for the floodgates to open. At some point, we'll talk about a couple of cases in other states where creative attorneys have pursued these mechanisms, and the courts in those states have allowed it to proceed, which means you then get to a jury, which means you have a decent chance of at least winning. So it hasn't really happened yet in Florida. And if it were the right case, I would try it. Now, let's discuss what really happens for the most part whenever you try something new in your state, even though maybe it's worked in 2 other states. Judges are very disinclined to want to allow it. You get motions to dismiss, motions for summary judgment. Judge, this has never been accepted in any court in Florida. And a lot of judges will throw it out. And then you're left with, is this the case you're going to appeal to the District Court of Appeals? Because that requires money. Or a lawyer who's going to continue on a contingency basis and is really dedicated. And sometimes, we can do that, sometimes we can't. Or it takes a bigger case where, it's well worth it. Sometimes, and who knows what would happen in Florida if it were tested, sometimes you find a receptive judge, a receptive circuit court judge, the first judge you see, a trial level judge, who might say, well, gee, invasion of privacy? This meets all the elements of an invasion of privacy. I'm not going to dismiss this. And so, okay, you go to a jury, hopefully. Hopefully you win. And then maybe the other side takes it up on appeal. It's the only way law is really made. See, if you win in the circuit court, it's hard for us other lawyers to figure it out, unless it gets put in the paper or something, which something like that would. But usually, somebody does something successfully in a trial level court in another county, another judicial circuit. There's some aspect to trial level records, but judges don't write opinions, and it's haphazard. Where you get the law is in the appellate level. So somebody appeals this first effort at trying invasion of privacy to deal with HIPAA. And let's say they won, so it's the other side taking the appeal.
They would be setting a new precedence, wouldn't they?
Absolutely.
Okay.
So let's assume, for the sake of argument, this happened here in Fort Pierce, where the radio station's located. We're in the 19th Judicial Circuit. The circuit court you'd be using would be in Fort Pierce. The other side doesn't like the verdict that you won. They appeal to the 4th District Court of Appeals in West Palm Beach, where 3 judges will hear the case. And they'll decide whether they believe the trial court was correct in allowing this case to go forward or incorrect. If they decide it was incorrect, they will remand with instructions to dismiss the case. And now you have to decide, do you want to go up to the Supreme Court to even ask whether they will hear it, because they don't have to. And I mean the Florida Supreme Court. Now, if the judges decide that perfectly legitimate way to handle this issue, we are affirming the jury verdict awarding you $18 million. Well, now we have precedent in the state of Florida that invasion of privacy is a mechanism to utilize on HIPAA violations. See, right now we don't, but other states, a couple of them, are beginning to allow it. And that means that other creative lawyers, I'd like to count myself within that branch, will try these things and see if we can get them to work here. So the normal, typical response I have been giving people, which is, you don't have any rights to sue under HIPAA. There's very little that can be done. If you want to file an administrative complaint, you can, but there's really not much we can do to help you. Now, that song and dance has to be modified to, well, it's unlikely that we can help you. There's no private right of action under HIPAA. But, given the facts that you've just explained, which are egregious facts, maybe we should talk to you further and see whether this is the case that we want to file on a breach of contract or invasion of privacy, or another tort. Some states are using negligent infliction of emotional distress. Well, in Florida, the tort of intentional infliction and negligent infliction has almost been eliminated by our Supreme Court. It is almost down to the point where unless a parent sees serious bodily injury or death to a child happening in front of them, that suing for intentional or negligent infliction of emotional distress is almost gone in the state of Florida. And the rationale that the Supreme Court has utilized in its opinions is that these types of torts bring a floodgate of frivolous lawsuits.
Sure, yeah.
And so essentially the tort doesn't exist anymore except in these very limited circumstances. Now, look, I understand that. I think that was like, throwing the baby out with the bathwater. There are lots of very serious cases that really do inflict emotional distress. Serious. I mean, I had a client many, many years back who was working at a dentist's office, and the dentist came into the staff meeting with a gun. Not to hurt anybody, but they didn't know that. Brandished the gun, and my client freaked out because she had had a prior incident with a gun in her life, and she basically hid in her master bedroom closet for 2 weeks and went into counseling for 5 years. That, I'm sorry, that calls for intentional infliction of emotional distress, but it wasn't available because the Florida Supreme Court has said it doesn't qualify. So I understand the rationale. Me, little lawyer, here, nobody cares about. I don't agree with it. But that is the way it is, and we have to live with it. So we try to find, other mechanisms to get at the same remedy.
If everyone can see your medical records anyway, what is HIPAA really about?
What do you mean everybody can see your medical records? Are you crazy?
But your medical records now are online.
No.
Every doctor that you go in the network can see it, so every office person.
First of all, wait a second.
Who? I'm just saying, who does it protect, and who can access your records?
All right, well, okay, let's talk about that, because HIPAA prescribes who can access the records, under what circumstances, and where are the exceptions. Okay? So it is prescribed very carefully, and it's not like anybody can go look at your records. Are they online electronically? Absolutely. This is our 21st century technology. But that doesn't mean, subject to being hacked, that anybody has access to them. So let's basically talk about that. HIPAA protects what you would expect it to protect: personally identifiable information about your health. So if it's a diagnosis, if it's a treatment regimen, if it's prescriptions, anything like that is protected. It's covered under HIPAA. And who has to abide by HIPAA? Who has to obey HIPAA? Well, it's health plans, healthcare providers, healthcare clearinghouses that keep all this information, business associates who assist in the providing of care. So not your provider, but they send it to this out-of-network place.
Mm-hmm.
They have to abide by HIPAA. All right, so to whom may the information be disclosed? My goodness, there are several categories that are in the statute, and I did make notes of it this morning. First, it can be disclosed to you, obviously.
Mm-hmm.
That makes sense. Second, it can be disclosed to treatment, payment, healthcare operations that are involved in your care, that particular care. Okay? So, Dr. A and Dr. B are both treating you for something. Dr. B can look at Dr. A's medical records. Billing issues, they have access to your information. Okay. How can it be used? Well, it can be used basically to assist in the providing of care or billing and any other natural, incidental related use. And there can be many.
Okay, yeah.
But
Anything
they're
instant could be.
legit-
Let me ask you this:
legitimate.
you're a suspect in some sort of situation where they're wondering if you're on psychiatric medications.
Subpoena.
The police, okay, but they
Subpoena.
can.
Yes. If the provider is subject to a subpoena, they are supposed to assert the privilege, doctor-patient privilege, whatever, and then it is up to the judge to determine whether or not there is an applicable exception that justifies the disclosure of your personal medical information in that instance pursuant to a subpoena. And, of course, we're going a little bit afield now, but if the court says, yes, obey, then most likely the provider's going to obey because, what do they care?
Mm-hmm.
If you don't want them to obey, then you're going to have to intervene and seek a writ from an appellate court to put it on hold pending the appellate court's ability to fully hear a case. And, that does happen on a regular basis. It happens even in the criminal law context. They want to search your house, or they searched your house and they found something and, now they're going to tell somebody else and you don't want it told. Well, you file a motion with the court. If you lose it, you go up to the appellate court. Depends how far you want to push it. But no, it's not just available willy-nilly. And it has to be relevant. For example, let's just say you are suing for medical malpractice. And you claim that your shoulder problem was caused by the doctor. You've never had shoulder problems before in your life. And they have information that you had shoulder problems 20 years ago that may have aggravated, the situation.
Mm-hmm.
And they subpoena that provider because somebody squealed. That provider is required to obey a subpoena, but you have to be notified and have a right to object before the records are disclosed. In that situation, should your medical records with regard to any shoulder issues be subject to disclosure? Yes. Completely relevant to your medical malpractice lawsuit. Should the fact that you were raped when you were 12 be disclosed because they want all your medical records? No. So that's where the subpoena then gets narrowed to what is relevant in that situation.
Yeah. For me, it seems as though all HIPAA does is prevent loved ones from being able to care for people who are sick and can't care for themselves at home.
That occurs too,
Yes.
but all you have to do is sign a piece of paper,
Yeah.
and they have access.
Yeah, they're not that smart at the insurance company. They don't look.
Now, there are a number of other public interest and benefit activities as an exception. And they list 12 of them. I mean, it's very specific, if it's required by law. if it's a victim of abuse, neglect, or domestic violence, if it relates to judicial and administrative proceedings, law enforcement purposes, cadavers, organ, eyes, or tissue donation. There are all these exceptions that say when certain information of yours that is otherwise protected under HIPAA may be disclosed, and to whom, and under what circumstances, and why. And it's not a bad statute. It's a good statute with a good idea behind it. The problem is, what were the legislators thinking? Who passes a law to protect consumers? Because that's what we are. We're consumers of medical care.
Yep.
Who passes the law to protect consumers and says, consumers, you can't sue? I don't know. Yeah. Were they all on marijuana? Did they all come from a late-night filibuster and didn't realize that Section 18 was missing from the statute? I mean, virtually every statute that affects the public has a private cause of action in it. And if it doesn't, there's usually a very specific reason why it doesn't.
Because you have to just sum it up as, how does this protect me then?
It protects you,
if
but if they breach it, you do have recourse. Let's go there too. You do have recourse. I don't think the recourse is great, but there is recourse. What HIPAA provides is that you may file an administrative complaint with the Secretary of Health and Human Services. There's a form. Hey, there's a form for everything in government. I don't know if it's called SD 125-23 revision 18. Who knows? But there's a form for everything in government, except maybe keeping the government open today. Here's my little political comment for the day. But you can file an administrative complaint with the Department of Health and Human Services that technically is addressed to the Secretary, who will never see it. And they have a procedure where they would investigate, and it is prohibited. You cannot be retaliated against for making this report. So if you're an employee, for example, there is an anti-retaliation provision, which is where I love to come in, because when stupid employers punish employees for doing things that are called protected activity, it makes it so easy for me. I love those cases. All right. So how do you get that compliance? You file your complaint, they investigate. Oh, that's wonderful. So what happens if you're right and what they did was wrong? Depending upon the severity of it, there are civil money penalties that can be assessed. And there is an amount, I don't have it here, but in the statute it says what the maximum is, how much it is per incident, if it's a second offense, a third offense, a fourth offense, it goes up higher and higher and higher. And, it's designed to eventually teach a particular provider, small or large, a lesson. Don't keep doing this. So, that could theoretically, it helps the public. Doesn't help you. Okay. There are potential criminal penalties. Now, I honestly don't know, and I didn't check to see whether there's ever been anybody pursued and prosecuted or convicted for the criminal penalties under HIPAA. But, hey, it's there. You can get up to 10 years in prison and a $250,000 fine. That sounds pretty serious, but if it's never used, then, who's afraid of it?
Yeah.
We've had some very high-profile cases of HIPAA violations. Michael Jackson, Anna Nicole Smith here in Florida, okay, where nosy people that were employees of the hospital or what have you decide, I want to go in and check. Now,
well, they may have been offered money from Inquirer or somebody.
They were fired.
Down the road.
I know here in the Anna Nicole Smith case here in Florida, those people were fired. I also know of a situation that I won't get into other than merely stating what I know, where at Martin Memorial, people were fired en masse for a violation of HIPAA. So, it's not that it's just violated and ignored willy-nilly. I don't believe it is. I think most providers make a serious effort to abide by HIPAA.
Well, I mean, you could even be violated and not know it. Like in our case with this relative, the only reason why we knew she was looking at everybody's medications is because she said so. Innocently, hey, you're taking the same stuff as
right.
And you're what? What?
It slipped. Yes, absolutely.
So who else are they looking at?
That's a pretty good question.
Yeah.
You
may not know.
So we were talking earlier. Now we find out now, okay, you don't have a private cause of action. You can make this complaint.
Mm-hmm.
There could be potential civil penalties. There could be criminal penalties. And you're out of the loop there. You're done.
Mm-hmm.
You filed your complaint. If they need to contact you, they will. Other than that, they're not going to let you know what they did. You've just done your civic duty. You filed your grievance.
Mm-hmm. And you hope somebody may get fired.
Go on with your life.
Yeah.
And frankly, as a lawyer, I don't think that's satisfactory. And I don't think it's satisfying, particularly if you've been hurt. Okay, then there needs to be a remedy, and hopefully these other remedies will work. So let's give the two examples that I was going to give, since we still do have some time, and we'll actually try to go through this. There is a case from Connecticut, not too long ago, 2014. This stuff is relatively new. And the name of the case, for anybody who cares, I've got to take my glasses off, is Byrne versus Avery Center for Obstetrics and Gynecology.
Ooh.
And in that case, the Connecticut Supreme Court held that HIPAA could be used as a basis in establishing the standard of care for negligence. Now, let me explain what that means. When you sue for negligence, you sue a doctor for negligence, let's say it's a malpractice case. How is negligence determined? What is negligent? It is falling below the acceptable standard of care. Now, the standard of care may be different for a general practitioner, your primary doctor, an oncologist, a surgeon, a specialist of other kinds. They're going to have different standards of care. And so how do we determine which one applies? Well, experts testify. Well, this oncologist should have known that for this particular procedure, it is no longer acceptable to use this technique. That was done away with 5 years ago because we now have much safer techniques. And if he doesn't know that, then he hasn't been keeping up with the literature and he fell below the standard of care. Okay, so that's how you prove a standard of care. So what the Connecticut Supreme Court was saying is that for negligence, we are going to use HIPAA as the standard of care. So those people didn't sue under HIPAA. They sued for negligence, and HIPAA became the way to prove the negligence. So if HIPAA says you must do this, and you didn't do it, the Connecticut Supreme Court was saying, you fell below the standard of care. You were negligent, and now you are responsible for any damages which were proximately caused by your negligence. So, according to the court, and this is a quote, to the extent that it has become the common practice for Connecticut healthcare providers to follow the procedures required under HIPAA in rendering services to their patients, HIPAA and its implementing regulations may be utilized to inform the standard of care applicable to such claims arising from allegations of negligence in the disclosure of patients' medical records. End quote. Now, I personally would say that is a very enlightened decision. In my personal opinion, it is a very correct decision. To whatever lawyers decided to pursue that case all the way up to the Supreme Court, which meant either they lost below, most probably, or they won in, provider appeal, but most likely, if I went and looked, I suspect they lost in the trial court, they lost in the appellate court. There's no such thing. You can't sue under HIPAA. Well, we're not suing. Hey, it sounds like you're suing under HIPAA. And then they get to the Connecticut Supreme Court that says, no. This is how we're going to do it. HIPAA becomes the standard of care. If you didn't follow HIPAA, you're negligent. Jury, how much you want to award? Now, of course, it's like any other case. Mm-hmm. It's based upon the severity of what was done and the severity of the damage caused. And if really no damage was caused, you get $1. It's called nominal damages. You win. And the jury award you $1, $10, whatever it is. Just so that you can say, I won. But if you were really hurt, somehow, if let's say, it's still very uncommon, although not completely uncommon these days, in professional football to have a gay athlete, somebody who's openly homosexual. Mm-hmm. I mean, that was unheard of, but now it's not. But it's still unusual.
Well, because we didn't hear it, it didn't mean it didn't happen.
Oh, you're absolutely right.
Of course.
You're absolutely right. But it's still unusual. So let's say you have an individual who does not want to come out and disclose that. And somehow, as a result of some medical tests, it comes out. And, his contract is dropped at the end of the year. And now he can't find another team that will take him. He's been damaged pretty severely. I don't know, maybe there's going to be a 20, 30, 40, 50 million, depending on how good of a player he is. So, it really depends. Now, we only have a couple minutes, so let me just get to the second case. The second case came out of South Carolina in 1997, so this has been around for a while. McCormick versus England, where the court recognized a duty of confidentiality for physicians and said that in the absence of express legislation, in other words, HIPAA doesn't provide a private cause of action, courts have found the basis for a right for wrongful disclosure in 4 main sources: state physician licensing statutes, evidentiary rules and privileged communication statutes, common law torts, and violation of the Hippocratic Oath. Wow. Another interesting level for a standard of care, the Hippocratic Oath. So you have now South Carolina and Connecticut that are allowing these types of cases to go through. Onward ho.
But then wouldn't they have to prove that the actual doctor was the one who disclosed the information?
Well,
and
whoever
not
they're suing.
Someone in their office?
Well, that's what you go into discovery. Then.
Okay.
I mean, yes, it's not everybody's responsible. So, folks, HIPAA, great statute. Call most attorneys' offices if they know anything about it. They're going to tell you can't sue under it. You're absolutely right. I'm absolutely right.
Should we tell our attorney to get creative?
If you've heard me, either you should tell your attorney to get creative or make me your attorney. Give Cheryl a call at 781-8003. And as we close out yet another show of Ask a Lawyer, let me tell you something. Having done this now for 6 months or so, and not knowing in the beginning first whether anybody would listen, whether anybody would care, or even whether I'd be any good at it, it's refreshing to know that people listen, people are being helped, people like it, and I have fun doing it. So have a great weekend, folks. Hopefully a warm one, and we'll see you next Friday for Ask a Lawyer.